Welcome to my channel. Please like, comment, and subscribe. What is maritime law? Maritime law is the collection of laws and agreements that govern behaviors and activities on the seas. The area of the law governs how people interact and do business on the waters of the world. Also called Admiralty law, maritime law primarily governs activities on international waters. However, there are also laws that apply to waters in and near each country. Generally, each country applies their own laws to inland waters like lakes and rivers. When most Americans board a cruise ship, they are blissfully unaware of the maritime law that applies to their case. However, maritime law affects everyone who travels on the high seas. Material laws regulate a wide variety of activities and possible events, including commerce, navigations, lost cargo, leisure travel, and the interaction between employers and seamen. Where does maritime law come from? Maritime law is a collection of international agreements and domestic law. Many domestic laws codify and give domestic enforcement power to international agreements. In the United States, maritime law is a mostly federal law. Sometimes, things like personal injury cases that occur on the seas might go to a state court. However, laws that specifically address maritime issues and activities are federal laws. Even when a case goes to a state court, federal law typically applies. A lot of modern codified maritime law comes from British principles of a common law. General principles of maritime law. There are several rules and principles that apply to activities on the high seas. Maintenance and cure. When a seaman is in service to an employer, they have a right to appropriate injury care. When a seaman gets hurt on the seas, their employer must treat them. The term for this responsibility is maintenance and cure. A seaman has a right to treat until they have received the maximum possible medical benefit for their injuries. They have right to treatment until the journey ends. The Longshore and Harbor Workers' Compensation Act requires ship owners to provide a system that is similar to workers' compensation for injured seamen. Duties to passengers. When a ship carries passengers, they have a duty of reasonable care to the passengers. That makes the ship owners liable for negligence claims that arise during the journey. Typically, American passengers can bring claim in U.S. federal courts. Terms between the passengers and the carriers may provide for a choice of a forum. In most cases, ship owners state that the passengers must bring their cases in Miami or Seattle. Courts generally enforce this choice of law agreements between passengers and ship owners. Lien and mortgage. Contractual disagreements arise that involve companies who do business on international waters, just like they do for companies that do business on land. When these disputes arise, those involved must have a forum to resolve their disputes. In the United States, contract disputes involving maritime activities go to federal courts. Examples include defaults on loan for maritime activities and wage disputes involving maritime employees. Salvage and Treasure. When a party recovers lost treasures and other lost cargo, a question arises as to how to fairly divide the recovered property. The party who owns the property generally has rights to it. However, the person who recovers it has a right to a reward. Salvage cargo can be money, and it can also be historical artifacts. A party trying to salvage lost cargo can enter into a contract with a property owner. That contract can state the amount of the salvage reward of the parties will enter into a contract ahead of time. The party that salvaged the lost cargo still has the right to a reward. It is up to the court to decide an appropriate amount of the reward if the parties cannot agree. The amount of the reward depends on risk of loss that the party incurs and other merits of the case. There are formal rules for engaging in salvage operation. Life-saving on a high seas. There is no salvage reward for saving a life. Seamen are expected to do their best to save the lives of those in danger on a high seas. There is no right to a reward for saving someone's life, but seamen are obligated to do their best to help others in perils. Duties to clients. A ship owner has a duty of care to their clients. If a ship transports cargo for alliance, the ship owner is responsible for the safety of the cargo from loading to discharge. There are a few exceptions, like acts of God and perishable goods. Unique jurisdiction consideration. Article 3, Section 2 of the U.S. Constitution gives the U.S. federal courts jurisdiction over maritime laws disputes. The federal court's jurisdiction is not exclusive. Some types of cases can still go to state courts. Cases that involve property disputes like salvage cases always go to federal courts. Cases like damaged cargo, products liability, and personal injury can go to state or federal courts. For maritime lawyer, concurrent jurisdiction presents some unique questions and challenges. Even a state court applies federal law. A state court always applies its own procedures. The difference can be significant. For example, in federal courts, there is no right to a jury trial except if a seaman brings a claim against the employer. And then investigating a prosecuting crime on high seas. The U.S. Coast Guard enforces a maritime law within its jurisdiction. The United States has jurisdiction up to 12 miles from its coast. The United States has limited jurisdiction for another 12 miles, and the Coast Guard and board vessels and investigate illegal activity in these areas. In U.S. jurisdiction, U.S. law apply beyond the limits of the U.S. waters. The law that applies in the law where the ship is registered. Even if a company markets to American passengers, their ship may register in another country. Criminal justice is a unique challenge when crimes occur on a high seas. Who practices Admiralty law? Admiralty lawyers are highly skilled litigators. They must understand federal and state laws and have sound judgment to help clients choose the proper and advantage firms. They must know what laws among the myriad of international agreements, federal laws and state laws that exist that might apply to the case. Admiralty lawyers must know how to successfully advocate for their clients using the rules, procedures, and the body of law that applies to the case. Maritime law is a highly skilled and specialized area of law. There are not many attorneys that specialize in maritime law because there is a lot to master to practice in a field effectively. Lawyers who specialize in a field tend to gravitate towards the courts, as lawyers might represent many different clients, or they might represent one client who regularly has maritime law needs. A lawyer might work in an advisory capacity or handle disputes and formal litigation. Why become a maritime lawyer? Maritime law is a specialized and exclusive area of law that can be financially and personally rewarding for attorneys in the field. If you are interested in providing high-quality legal service in a niche area of civil litigation, maritime law may be for you. Maritime lawyers may develop a private practice that also includes other aspects of civil litigation. They might also find stability in their career by focusing on sole clients. Maritime law is a challenging and rewarding area of law that requires unique knowledge and abilities. Lawyers in the field may enjoy a unique and satisfying practice of law. I think that's all, guys, the information that I can say to you. Thank you so much, guys, for watching, and thank you. I hope you can take advantage from the video that I have shared to you. Don't forget to give a like, comment, and subscribe. Bye bye. See you in another video, guys.